In 2020, on November 5, in a town called Liverpool, New York, a suburb of Syracuse, New York, on the shore of Lake Onondaga, a worker was killed. This fatality occurred while he was serving as a spotter, while pipes were being loaded onto a flatbed truck. These were torch cut, decommissioned steel poles used in power transmission. OSHA issued a citation under the forklift standard and then modified it to a revised allegation under the general duty clause. We're going to talk about the administrative law judge's decision on this episode of the OSHA 3030 with Manesh Rath. Hello, everyone. I'm Manesh Rath at the law firm Keller and Heckman. I'm an attorney representing management in the field of occupational safety and health law. I've been doing this for about 28 years on the management side, and I am joined today by my friend and colleague, Taylor Johnson. Taylor, welcome.
Manish, thanks for having me. Pleasure as always.
It's my pleasure. Taylor is a valued part of the team engaged in assisting our clients in the fields of occupational safety and health law, and as well environmental law, transportation law, a number of other fields. So thank you for joining us. Taylor, we've got a really important discussion today because it really centers around the general duty clause and with specific respect to where people should be positioned when dangerous operations are taking place.
Yeah, that's exactly right. And so we'll start with the facts of this case, which was Secretary of Labor versus CNS Technical Resources. And then just like you said, Manish, we'll talk about the general duty clause and what OSHA needs to prove to establish a general duty clause violation.
So originally, OSHA issued a citation under the Powered Industrial Truck Standard and then modified it to the general duty clause. We're going to talk about, as you say, the general duty clause violation generally, but when they migrated their amended allegation to the general duty clause, there was also this preemption argument that was opened up to the employer. And so we'll talk about their arguments, the administrative law judge's decision, and how he dealt with the employer's arguments.
Yeah. And then as always, we'll wrap it up with what employers should do, some practical takeaway action items for you to bring back to your workplace.
One of the best parts of the program. This is pre-recorded, and so we won't be doing the final section that we do about half the time, which is a live version for attendees of the webinar only. But this is pre-recorded. We're going to post it as a podcast, and so we're going to skip the live off-the-record section.
Yep.
Okay, so let's get into the facts of the case.
Yeah, so CNS Technical Resources was hired to torch cut decommissioned steel power transmission poles, load them onto flatbed trailers. Just to give you a sense of the weight and the size of these poles here, CNS estimated the weight of the segments to be between 4,000 and 8,000 pounds. So no small feat here to load these poles.
Right, and they were maybe as long as 80 feet long, but they were cut into 20-foot segments.
Yeah, that's right.
So there's really three employers here. I think we need to understand what's going on at the site. So first is the transmission company, and they were trying to decommission these poles that were used for power transmission, for running lines, power lines. And when they decommissioned them, they sold the broken down pole segments to a scrap metal company. In between the two is a specialist who engaged in the cutting and the loading, but it was the scrap metal company who brought its flatbed trucks onto the site of the power transmission company's yard and had them loaded by this intermediate specialist company, C&S. This is the company that was ultimately issued citations by OSHA.
Right. And so that's the lay of the land for the employers. In terms of the employees, there's really two main characters in the story here. The first is the foreman, who's operating what they refer to in the case as a telehandler. Essentially, it's a forklift with a boom attached to it. And so the foreman was operating the telehandler to handle the poles, pick them up, load them onto the flatbed truck. And then the spotter, who ends up actually suffering a fatality in this case. But the spotter is the other employee that we need to keep an eye on. He was available to spot when the foreman operated the telehandler.
So the telehandler is being operated by a CNS employee, and the spotter who's standing next to the flatbed truck is also a CNS employee. Right. The flatbed itself belongs to the scrapyard, but they don't have any employees involved in this incident.
Right.
And so the operator of the telehandler is loading segments onto the flatbed. And what he does for the first 10 days of the project is he loads up one pole segment and next to it another pole segment on the front half of the flatbed, and then on the back half another pole, and beside it another pole. So it's never stacked. It's always only one pole high. And they roll the flatbed trucks off the site in succession for 10 days straight. On the 10th day, somebody asks the driver how he wants them stacked, and he says he wants 6 segments loaded onto the flatbed, 2 side by side, and then a third one on top of it, on top of the first 2 in a triangle kind of configuration, and then behind that another 3 in the same triangle configuration. So when you take 2 poles stacked side by side in the valley created between the 2 of them, abutting each other, rest a third pole segment on top of them. Now, these poles, I'm calling them, they're really 12-sided, so they have a kind of look that they're round, but they also have a base plate that's square on one end, or in other occasions 2 ends, but mostly one end. So the belief of the staff at the time was that the square base plate kept the pole segments from rolling. So they abutted 2 of them and put another one on top.
Right. And so what ends up happening is that while attempting to load an additional stack, one of the segments slips from the lifting fork, and it causes the loaded stacks to collapse. And then one of the segments struck and unfortunately killed the spotter.
So imagine a flatbed that is at least 40 feet long, and in the front half, closest to the tractor, there are 2 pipe segments laid on the flatbed, and then a third one on top of it, all of them having square base plates. And then on the back half, closest to the taillights, there is another 2 pipe segments or pole segments laid on the flatbed, and the operator of the telehandler is lowering the third segment on top of those rearmost 2 segments.
Yeah.
And as he lowers it, he lets it go from the tines of the forklift only an inch or 2. It falls only an inch or 2 into the valley created by those 2 resting pole segments. But with that inch or 2, it picks up enough momentum that it splits the load that it's supposed to rest on. The load closest to the driver's side falls to the ground, but there's nobody around. Nobody gets harmed. The other pipe or pole that's closest to the what I'll call the passenger side stays put. It has 2 square base plates, one on each end, so it doesn't move. And then the one he's loading kind of falls onto the flatbed. But the weight and the impact upon the flatbed of this event is such that it unsettles the front triangle of pole segments. And the base pole segment on the driver's side falls to the ground. And as it does, the spotter is standing on the flatbed next to the front segment of poles, the front segments of poles. And so as it falls out, it knocks him out off onto the ground. It sweeps his feet, and he falls off the flatbed onto the ground. Unfortunately, the topmost pole of that front load falls down to the flatbed and then tumbles onto the ground after it and hits him and kills him. And that is sort of like a Rube Goldberg sequence of events. Remember, all of this started when lowering a pole onto the rear stack, not the front stack. He's standing next to the front stack. He is 10 feet away from the closest end of the rear stack, and 18 feet away from the tines or any of the closest portion of the telehandler. So he's quite a distance away from the zone of activity. I'm going to use the zone of activity. I made that up, but it kind of describes what's going on in that rear stack. And he's 10 feet away from the closest end of that rear stack. And so that's quite a distance.
Thank you for painting that picture. It was hard for me to visualize all of that when I was reading it. It's, all of a sudden they kind of just cut to the chase, and it ended in a fatality. But you
have to read it 2 or 3 times, and then you realize that this is sort of a Rube Goldberg sequence of events where
all the things that
one thing knocked into another, and then the impact caused another to tumble, and then a third thing tumbles, and it's the third sequence of events that strikes him and kills him. So harder to foresee, I think.
Certainly. And so OSHA does come out, obviously, investigates the incident. Two citations. One, it starts off as a powered industrial truck standard citation for failure to train. And then it's amended, the citation, into a violation of Section 5A1, the general duty clause. CNS appeals the citation, obviously, gets assigned to an ALJ for adjudication, which brings us current.
So the general duty clause, we've talked about this so many times at the OSHA 3030. It's one of our favorite subjects because it's one of OSHA's favorite
Right.
sections to issue
Right.
citations under. Here, there was a powered industrial truck standard. They issued, after amending, they issued it under the general duty clause, and that makes their burden a little bit higher because under a standard, when OSHA issues a citation, they simply have to prove that the citation applies to the activity or task being performed, that there was a non-compliance or non-conformity between the way the task was performed and the requirements of the standard, and that there was knowledge and exposure. But when OSHA wishes to say that there was no specific standard on point, but we're nevertheless issuing a citation under the general duty clause of the Act itself, Section 5A1, they are basically saying you have failed in a generic duty to maintain a safe and healthful workplace so far as is achievable. And to do so, they have a series of elements they have to establish. One, that the condition or the activity being performed in the workplace presented a hazard. And as the administrative law judge, Judge Coleman, who's a good judge, correctly points out, it is the hazard that the law has to focus on and not whether or not an incident occurred. Whether there was a hazard or not a hazard is the focus of this element that OSHA has to establish. The second is whether or not the employer or its industry generally recognized the hazard as being hazardous. And the third is whether the hazard in question was likely to cause death or a serious physical injury. Now, this is important because if OSHA is issuing a alleged violation under a standard, it needn't prove that violation of the standard was likely to cause either serious physical injury or death. It could be a non-serious injury, or it could have been a paperwork requirement or a training requirement where the connection between that failure and any injury, serious or otherwise, would be, maybe it doesn't need to be approximate causation. But here, OSHA, under the general duty clause, OSHA would have to prove that the hazard did cause or was likely to cause a death or a serious physical injury.
That's right.
And the other point I'd make is a serious physical injury. So health effects are per se outside of the scope of this element.
Right. That's a great point. And then the last two are, so after you prove that the hazard is likely to cause death or serious physical injury, OSHA needs to show that a feasible and effective means existed to eliminate or materially reduce the hazard. And then finally, the last element, that the employer knew or could have reasonably known of the hazardous condition or activity. And I'll point out here, in terms of this case, the CNS case, it's the second prong here, that the employer or its industry recognize the hazard, which is really the focal point of the case. OSHA argues sort of both here. That they say that not only did CNS recognize the hazard in its own sort of operator manuals, but that also that industry itself generally recognized the hazard. But CNS pushes back, and the ALJ's decision really sort of turns on this second prong.
So what is the hazard, does OSHA say in its alleged violation description? It says it's not the question of the loading and unloading that was handled in an unsafe manner, and therefore the powered industrial truck standard doesn't even apply. You see, CNS alleged that if there's a specific standard on point, then that preempts use of the general duty clause. That, although that is not a statutory rule, it has been observed for years in the compliance directive, in the field inspection reference manual. And so it has become a sort of self-imposed rule by OSHA that employers have raised as a defense. And in this particular case, the judge said, well, remember, we have to focus on what the hazard is, and they're not alleging that loading and unloading operations are handled in an unsafe manner. They did actually cite a separate citation for certification under the powered industrial truck standard, but they did say that this particular general duty clause alleged violation was that the employee, the spotter, was standing in a dangerous location. And So your point is well taken, Taylor, that the key here for CNS, the employer, their defense was that either the employer or its industry would have recognized what a zone of danger was in order for OSHA to be able to successfully establish its violation, but alleged violation. But in this particular case, there's no generally recognized industry acceptable zone boundary for a zone of danger for inside of which employees may not stand or position themselves while performing their work. OSHA, in order to establish that there was a generally recognized zone of danger, pointed to one or two pieces of evidence. And I think that that's the key to OSHA's argument that there is a generally recognized zone of danger while conducting dangerous activities. And here, by the way, I don't know that it really applies specifically to powered industrial truck loading and unloading.
Mm-hmm.
I think anytime you have multiple machinery pieces of equipment moving around and stationary workers, you have an opportunity for a strike hazard and there may be a danger zone. So this would also apply to moving vehicles, cranes, derricks, etc.
Yeah, that's a great point. And you actually see that in the first type of evidence that OSHA puts forward here, which the first is these operator manuals. So they point to two warnings. The first is that, a danger zone is just any zone around the machinery. So again, to your point, Manesh, just machinery in general, in which a person is subject to risk to their health or safety. And then the second one, even more sort of higher level than that, just work sites can be hazardous, persons can be killed or injured. So those are the two types of written evidence that OSHA puts forward. And then they also advanced two of their own experts. One was just a compliance safety and health officer, and the other was a registered engineer. Although interesting, the ALJ
both were employees of OSHA.
Yes, both are employees of OSHA, and the ALJ ends up determining that neither was a qualified expert, which is I thought very interesting.
The compliance officer would have had to have been qualified as an expert witness if he was going to offer expert testimony, and he identified his opinion in the midst of his factual testimony. And so, yeah, I think the judge made a very smart move to identify that that's improperly categorized as expert testimony. That's right.
Yep.
He can testify to the facts that he observed, and I think that's appropriate, and that is an appropriate application of the law.
Yep.
CNS's argument was, well, we think that the zone of danger is per se something that every employer has to exercise their own judgment and expertise at the time that the task is being performed, because every situation is different. And when you look at the language in the operator's manual, after all, it said that a danger zone is any zone in which somebody's subject to risk, which is a bit of a
right.
bit of a circular definition,
right,
and not very helpful.
Yes.
And the judge noted that as well. And I think that was a sharp pickup on the part of Judge Coleman, who I think is a good judge. He's turning out to be a great judge. He's relatively new to the review commission, having joined, I think, earlier this calendar year, if I'm not mistaken.
Yep.
But he said that, look, well, when you look at the operator's manual, yes, that is evidence. There's no question. That is evidence of what a generally recognized hazard might be. But when you look at what the operator's manual says,
yes,
it's not very helpful in that it has this, what he referred to as prosaic description of a zone of danger as anywhere where an employee might be at risk.
Right. Right.
And that's just not going to be dispositive. It might be probative, but not dispositive.
Yep, the judge does exactly that. He sort of zooms out essentially on the two portions of the operator's manual that OSHA cites to, and says, sure that that the manual says that, but the manual also, if you go into greater detail, it provides examples illustrating areas that are within the zone of danger, such as the immediate proximity to hazardous moving parts, into which equipment and attachments can be moved quickly. So, sort of OSHA's own evidence in this case, if you dig a little deeper, kind of establishes, I'd say, a tighter zone of danger than what OSHA was originally trying to argue. It says there needs to be a risk of being struck by the telehandler, its load, material falling from attachments. And the ALJ ends up finding that this sort of narrower definition of the danger zone is actually consistent with CNS's expert witness, who put forth in his opinion that the common industry practice is 10 feet, as opposed to the 18 feet away that the spotter was standing in this particular case.
Right. And that 10 feet was being observed by the spotter with respect to the distal, the closest end, the proximate end
Yeah.
of the poles pole segments being stacked, and 18 from the telehandler itself, or the closest part of the telehandler. So he was doing his level best to maintain a safe distance. He was standing next to at the time, stable load that eventually became destabilized by other activity 10 and more feet away.
Yep.
And I think that that was a significant part of CNS's argument. OSHA's expert testimony went to the reasonably predictable or foreseeable instability of the load, even when at rest, because when you place one pole segment on top of two others, it would have a opportunity to split the two apart and send them
Hmm.
tumbling. But the folks at CNS believed that the square base plates would have stabilized against that.
Yep.
And they may have been wrong, and they may not have even been terribly reasonable. But OSHA's burden is to establish that the generally recognized industry practice would have been to generally recognize that as a zone of danger.
Yep.
And I think that the judge just felt like they didn't make their case with the preponderance of evidence.
That's exactly right. So the LJ finds there's no evidence that the spotter was at risk of being struck by the machine, its load, or the material that it was carrying. So the judge essentially goes back to OSHA's own evidence there and reads that quote from the operator's manual. Again, notes that the spotter was 18 feet from the machine, and finally concludes that there's just insufficient evidence to establish that the spotter was within this industry recognized danger zone. The ALJ vacates the general duty clause violation. That's how the story ends.
That's right. Oh, and I suppose that if the spotter had been standing on that rearmost stack next to it,
It's a good
that
point.
that might have been a completely different fact pattern, and that Judge Coleman might have ruled in an opposite. But because specifically he was in the front, standing next to the front stack, which had already been loaded long before and was for the time being stably situated, the judge felt like that was an operative fact,
Yep.
allowing him to believe that there just wasn't enough evidence to believe that where the spotter was standing next to the front and temporally stable load was unequivocally or generally recognized as a zone of danger.
Yeah, that's a good point. Be interesting to see how the case turned out if he was standing on the other side. But
Right. I,
uh,
I believe it's more likely than not that it would have gone the opposite
yeah,
direction.
yeah,
Yeah.
yeah,
Well, that's the judge's decision. This is really important because when you look at the modern manufacturing site, construction site, warehousing, distribution centers, there are activities that all one can easily visualize apply to the concepts being discussed in this case.
yeah.
Anywhere you have powered industrial trucks, forklifts, cranes, booms, derricks, anywhere you have robotics,
Right.
you're going to have any moving parts. You're going to have the same opportunity for an employee to be careful to stand outside of a zone of danger. And a zone of danger is anywhere where there is a possibility of contact between moving parts and a worker. So this is incredibly important to a enormously large fraction of the American workplaces.
Yeah.
In light of which, I think that what an employer needs to do is try to identify the zones where A, moving parts or machinery can potentially strike with stationary workers, B, restrict the movement of non-stationary workers outside of the range of motion of those machines, C, separate workers from machinery or moving equipment in the lanes in which they travel to create separate and non-intersecting lanes wherever possible.
Yep.
Maybe it's not always possible. And D, of course, to have a system for signaling where intersections do become likelihood. But there's, of course, more. Uh, Signaling for equipment, proximity sensors are all additional engineering controls that could be implemented. And there are others, and they continue to grow in innovation to keep employees safe from either moving pieces of equipment or equipment with swing radiuses or sliding trajectories where the two could intersect.
Yep.
I think those are really critical, important steps that an employer can take
Yeah.
right now to reevaluate and create what they've identified as zones of danger for their employees. Now,
Yeah.
that is just the intersection between those pieces of equipment and the worker. Then there's the secondary effect of material that's being handled by the equipment that would create an additional circumference of an additional zone of danger that has to be marked out, understood, and then marked out.
Yeah.
So a hazard analysis for the equipment that's the material that's being moved around. And then the third is the possibility of destabilized or falling objects as well.
Yep.
And the fourth would be, I think, flying debris that could be caused in a reasonably predictable manner by any of the work activities at your work site. So
Yep.
those are the four theaters of zones of danger, possible zones of danger that I've just outlined for you that I think are extremely helpful to participants of the OSHA 3030 to walk away with that list and go back and do another hazard analysis if it's been a while since you've done your last one, or if there have been changes to your floor pattern or the equipment that you're using.
Yep. It's all great points. And to document all of that, right, as well. I think it
Right.
certainly would have helped CNS in this case if they would have had their own documentation, their own work practices that, for example, identified a 10-foot zone of danger or a more narrow zone of danger. I think that could have directly refuted OSHA's contention that, it was generally recognized and that CNS in itself recognized an 18-foot zone of danger, sort of this broader, application of that. They could have pointed to their own work practices right there that turns out they were actually doing in the field. So make sure you document that is also, really important.
Yeah, and I think they did the right thing by having a monitor, but there should be somebody supervising the positioning of employees. It could have been the foreman who was operating the telehandler in this case, but there has to be, when you talk about documentation, Taylor, there has to be documentation of observations and any reprimands or disciplinary action that's taken
Right.
if people violate any of these work practices.
Yep.
So that you have a record that you not only developed a policy, but or did a job hazard analysis, but that you've been monitoring and enforcing it.
Yep.
Okay. So that is today's OSHA 3030. That is another instance in which OSHA has struggled to meet all of the elements under the general duty clause. And yet it's been my general observation without actually measuring it that the incidences where OSHA has chosen to use the general duty clause has been on the increase. I'd love to see a measure or study if that's actually true, but it feels like they're using it more and more. And we've covered a lot of cases where they've struggled to meet all of the elements of the general duty clause. That's today's OSHA 3030, Taylor Johnson.
Well, thank you as always for having me, and thank you all for listening.
Our next episode
is September 25th, 2024. Always at 1 p.m.
Always on a Wednesday.
Always on a Wednesday.
1 p.m. Eastern time. We have sister programs, and if your operations are such that they must comply with either REACH or TSCA, you should know about these programs, or if someone else in your organization forward these programs on to your colleagues. The REACH 3030 and the TSCA 3030, they're coming up August 28th and September 18th, respectively. 10 a.m. for the REACH 3030, August 28th, and 1 p.m. September 18th for the TSCA 3030. Terrific programs, incredibly important. Not a lot of other content out there other than these programs and the attorneys at Keller and Heckman who are covering these subjects in such detail. So make sure your colleagues know about that if those are statutes you're obliged to comply with. On behalf of Taylor Johnson, the terrific staff here at Keller and Heckman, and myself, I wish to thank all of you at the OSHA 3030 for tuning in. August is our anniversary month. We started August 2013. So I believe that means we finished 12 years. I've often said, I think I've said in the past that we're in our 13th year. We're only starting our 13th year now. So I probably stretched it by a few months. Got ahead of myself. And so now happy anniversary to the OSHA 3030. Thank you all for joining us for all of those years. We have participants who have been with us since the beginning. We thank you. And we thank all of you for forwarding the invitation when you get it to at least 3 other people, not only within your organization, but to other organizations, safety and health professionals, as well as folks in your office of in-house counsel or the office of general counsel at your organization and at other organizations, so that the good word about the kind of information we're providing, complimentary to you, can be passed on to more people who are dedicated to the field of workplace safety and dedicated to making workplaces safer. Thank you all. We look forward to seeing you again next month. And until then, stay safe.